Divorce, as you know, is probably one of the single greatest loss an adult will go through.
Welcome to Talking About Kids. I am your host, R. Bradley Snyder, researcher, activist, and author of The 5 Simple Truths of Raising Kids. Divorce is hard on kids. My guest this episode is the attorney Charles Jamieson. Charles has spent over 40 years using his considerable skills and experience to help families around the country mitigate the damage divorce proceedings can cause. His insights are as practical as they are valuable, and I am grateful that he found the time to share them here. This episode is sponsored in part by the Arizona Department of Health Services Must Stop Bullying campaign through its Title V Maternal and Child Health Program. For more information, go to muststopbullying.org. And now, the interview.
I grew up in a small town in rural Maine, in northern Maine, and we had one lawyer in the whole town. And he was really sort of became the counselor, confessor to people. I mean, he knew everything that was going on, and he gave advice on all legal issues. But that's the kind of lawyer I wanted to be. And I think most people who end up in family law want to help people. But I also found it and remains fascinated by this intersection of various issues, legal and non-legal. You deal with family law, you deal with real estate law, you deal with trust in the states, any number of issues in a family law case. You also deal with other issues that don't have anything to do with the law, such as psychology, sociology, therapy. How does that work? So it's all these, you're learning, every case that comes in, I learn something new. Even after 41 years of doing this, I'm still learning every day. So that's what I find fascinating about family law. And it also gives me the ability to sit down with people, learn about their lives, try to give them advice, not only legally, but although I don't pretend to be a therapist, but on other aspects of their life. Let's get it together.
It's one of the things that really excited me about having you on talking about kids, because it was pretty clear, the little bit of research I was able to do on you, is that you don't approach this necessarily as a job. As you just described kind of your history of this issue, it seems to me that you're really concerned with how, in particular, divorce impacts the whole family, in all these different ways. And I guess my first question for you then is, what are some of the different ways that families can be damaged during divorce proceedings?
Well, a divorce, as you know, is probably one of the single greatest loss an adult will go through. And if you look at various studies that have been done on it, or commentaries on it, there's only one loss that's greater than the loss of a family in a divorce, and that's the loss of a child or a spouse.
Yeah.
So it's an incredible loss. Because of that, just that, and also the way the law deals with divorce is not conducive to healing. Divorce is an emotional process or issue upon which the society has built this artificial scaffold of laws, rules of procedure, and other statutes that are not humanistic in form. They're formalistic. I mean, someone often asks me, how does law change over the years? It's become more and more formalistic. What do I mean by that? Back when I first started, the judge would hear everything and there was no guidance. Now, if you look at statutes, child support is a calculation. Alimony more and more is becoming a percentage of income or a mathematical calculation. Even child issues, to a certain extent, are becoming more formalized. What do I mean by that? Formalized. What do I mean by that? When I started practicing, if you won custody, that's what we called it back then, then you won the whole shooting match. We've gone, father, and particularly women, were more awarded the custodial issues than men. Men were fighting for what they called more equal treatment in the courtroom. And whether it's men or women now on this issue, we find now that visitation or custody is more of a 50-50 proposition, whether it's by statute. Florida, where my office is located, just recently passed a statute the last year that starts off with presumption now that time sharing will be 50-50.
Mm.
When you start taking away this discretion from the judges, you're giving more power back to the parties, because there's certain things that if it's a formula, it's a formula. Now, does that mean where the lawyers fit in? Lawyers still fit in because there are still disputes. When you have a formula about income, you're fighting about income. What does income consist of? That's where the battleground is. If you're fighting with a presumption of 50-50 timesharing, clearly there are circumstances where it's not going to work. You have for younger children, if one parent has been primarily the caretaker and the other parent has been absent, that's a tough presumption to
Right.
overcome for a parent who's the primary parent in that category. It's not great for the kids. Um, for teenagers who might be dealing with refusal rejection issues in terms of visitation, in other words, they don't want to go on visits, whether they have a good reason or not, then you're starting to look at issues of parental alienation and estrangement. Which are different issues and different causes. So conflict. So judges, in my opinion, try their best, but they're clear that the parties are the ones that know best about their lives and how the, the history of how they've come to be where they are, and the parties are the best able to, rather than judges, to resolve that issue. What's a common fallacy for clients that get them damaged in the divorce process? They think that the judges have this ability to take their whole relationship in a detailed fashion, like a video on their lives from beginning to end. And they're going to listen to that, get all that information, and go back to their offices and try to carefully scalpel out a solution that takes care of their problems and their family's problems. Unfortunately, the reality is different. The reality is judges are hard pressed. They don't have enough time to hear cases. And they're not going to see the whole video of their life. They're going to get this picture, this picture, this picture, and this picture. And hopefully it will be the right pictures. But if it's not, we'll be on to you and your children. So the judges themselves will say, we're not the people who should be doing this. So where are we in terms of damage to families by the process? One is the process is not set up to be therapeutic in nature. It's not to heal, it's adversarial. You have if you get caught up in the adversarial context of your divorce case, even though 90% of the cases settle, you're still going to be litigating and be adversarial in that process, where we get now to parental conflict. When you have parental conflict, we all know what the studies tell us. Parental conflict in a divorce case and ongoing parental conflicts are the best predictor for bad things for kids in their future, both as children and as adults. So the system is set up to fuel that conflict rather than heal the conflict.
When you started to describe the formulas, some of the formulas to me seemed like kind of progressive, that we're looking at a 50-50 split, that we are using a calculation of income. But your description makes it sound like these formulas are making the process more adversarial. Am I hearing that right?
I think what you're doing is you're putting into focus. As much as these formulas attempt to smooth out the bumps of the road because it makes it more predictable what's going to happen, you are creating more conflict in certain areas.
Mm,
What do I mean by that? If you're not laying out clearly what income is, or even if you do, that's where the battle's going to be, because these formulas for alimony and child support come down from a calculation of the income. That's where the battle will be. What is my income? Is the income what the statute says? How am I trying to hide
okay.
income under those kinds of circumstances? On For the issue of time sharing, as we say in Florida, rather than visitation or custody. But
Okay.
for those issues, it's 50-50. If you're talking about teenagers, generally speaking, or middle school students, that's not a bad schedule. In fact, it seems to be progressive, and it seems to smooth out the bumps in the road. But you have these other issues. The one issue may be, what about children who are very young?
Mm,
Preschool age children who've been primarily cared for by one parent and the other parent's been absent. It doesn't, that 50-50 time sharing may not be best for them.
Right.
But now what you're doing is, particularly for people of lower income status, who can't have to now legal, mount up their legal team to fight that presumption because it's presumed. It can be rebutted, but you have to rebut. If you're upper middle class or upper class, you have the financial resources to do that. But if you're not, you're screwed by the system, and you get victimized by the system because you don't have the money. That you
Right.
have to take money that could be better used to support your family post divorce and spend it on that kind of litigation. Um, and then it also, you have the circumstance, still doesn't take care of the circumstances where what we call reject and refusal cases, where teenagers or middle school age students are refusing to go to visitation or time sharing schedules. And what's going on there? Is it parental alienation or is it estrangement? And so you have a 50-50 time sharing. It may not be appropriate under those circumstances. It may have to be changed, but that's creating other forms of litigation. So it may take care of a section of the
Right.
population, but you're still having a section where it's going to be litigated. And because there's a presumption that you have to fight against, you're going to see that rather than having less litigation, you probably have more litigation
There,
in those areas.
there's two terms that you've used now a couple of times, and I want to make sure that I understand them and that my listeners understand them. You've used parental alienation, and you've used estrangement. Can you explain what these things are?
Parental alienation is a process where a child has had a great relationship with the parent and then later doesn't want to have anything to do with their parent, refuses or rejects the parent without having any substantive explanation for why.
Mm,
There's no real good why. That's parental alienation. Estrangement is where you have the great relationship, bad relationship later, but there is a reason, such as the child may have witnessed domestic violence being committed on a parent or on the child's own against the child itself. May witness may be a victim of or maybe participating in what I call brittle parenting, that rigid kind of parenting that's overbearing. Um, so there's a reason for that to be happening. That's estrangement. But so the results look very similar. So it's easy to confuse one or the other. But that creates litigation. And how do we deal with that? The presumption does not, if you start with presumption and the kid saying, I'm not going, and the parent can't make them go or cannot force them to go or not required to force them to go, depending upon the law in your state, I mean, that's going to be an area that's ripe for litigation because
mm,
you got the presumption. So again, and we're seeing more and more of these kinds of cases, particularly where you have that highly contested, highly conflicted parenting component, which if you have, I mean, what the way you parent in your divorce is how you're going to end up parenting after your divorce. And we can say everyone like, can we just get along? But we do know that there's a certain section of the population that suffers from personality disorder or negative,
mm-hmm.
what I call negative personality characteristics in a high fashion, such that it has a negative impact on parenting, on co-parenting, and some parties just can't co-parent. We have this concept called parallel parenting, where people are sort of parenting side by side with as little contact with one another as possible because they have such high conflict.
Mm,
Um, the judges don't seem to recognize that, and that's an area of litigation. Why? Because the judges have this formalistic co-parenting. Everyone's going to be co-parenting. Well, not everyone's fit to be a co-parent, and that's where you see these constant battles going on, or constant parental conflict. Now, the other ways divorces are harmful. The divorce itself causes emotional stress on the parties because there's this great loss they're suffering. They don't know what their future is going to be like. And
right.
oftentimes you have what I call the disparate expectations of divorce, means one party is way ahead of the other in terms of deciding that this marriage is over and I'm getting a divorce.
Mm,
So they've got to catch up. That causes stress. There's financial stress. Parties know, most states, you're going to have a 50-50 division of marital assets. That's going to happen. So you're going to automatically have half of what you've worked so hard in your marriage to acquire. You're going to have child support payments. You're going to have alimony payments. And during a divorce, you have attorney fees payments. That causes financial stress on the parties. And then we have what I call the parental conflict. where you have the high conflict, you're going to have the negative results for children. That's been established since back in the
Right.
70s. When I first started practicing, even that was known, if not intuitively. Studies,
Right.
repeated studies have been done to demonstrate that to us. So that's how parties or parents or kids can be damaged during divorce.
Do you think that with the new kind of formulaic approach that family courts are taking, do you think that it's forcing the parties into more extreme positions about each other? In other words, is it forcing them to bring out and to bring to light kind of the worst moments from their spouse? Is it forcing them to emphasize incidents that they might not have normally emphasized?
I think so. And the other culprit in that is what I call notice pleading state. A
Okay.
notice pleading state is if you don't ask for it, you don't get it.
Uh-huh.
So you'll see a divorce petition that asks for everything from the wind, the moon, and the rain, whether the other side is entitled to get it or not.
Right.
Why do they do that? Because the attorneys are protecting their position by asking for it. So automatically, people go berserk when they get to serve with the petition because it's asking for things that, even if the parties may have been discussing settlement, there's nothing to do with it. In fact,
Right.
it causes an explosion, and most of the times when the spouse who's complaining or the other spouse is going to say, "I don't know anything about this. I never talked to this about my
Mm.
husband." So again, the system is set up by itself to exacerbate conflict within the course of the divorce case. Now, remember, 90 to 95% of all divorces settle,
Okay.
but you've got to get to settlement, which means can you get the parties to get to what I call settlement? This is the beginning of the case. Can you get the parties to settle close to the beginning of the case rather than at the time right before the final hearing? Because the majority of cases, or that 90 to 95% of cases, will settle, but at the eve of trial. So mediation, you go to mediation trials in a month or 2 months, you're going to settle because you realize by that time that either you're so financially exhausted or emotionally
Mm.
exhausted or both that you can't do it, nor is there any reason to do it.
Well,
So,
and you've worked in, if I've got this number correct, you've worked in more than 20 states around making the impact of divorce or lowering the impact of divorce on children. This is something that you've been very concerned about. So, what are those things? How should adults kind of, what should they know going into this so they can avoid some of those horrible things that we just discussed?
well, if we're talking about kids, first thing I've always done with my cases, or I've developed over the years doing, is what I call a divorce mission statement.
Mm.
What is that you want for the outcome for your children and you in this case? You want to be at the end of the case being like the classic people at war, that you're sitting at these events in your children's life, graduations, weddings, christenings, other important seminal events in your children's lives as they become adults or in their adulthood, and have two warring camps glaring at each other across the hallway from one another, or not saying anything to one another, sitting in stony silence? Or do you want to be people who are supportive of their children and can have a civil conversation? So that's number one. Now, I mean, the International Academy of Collaborative Professionals
Hmm.
has a film. That film's entitled A Safe Place. And then they follow a couple through the collaborative process. And they have a divorce mission statement in this for their kids. And I'd like to read it just for you,
Yeah.
for the audience to hear. See, for an example, one of these looked like. The statement for this couple was, "We want our children to grow up feeling loved and nurtured by both of us, without a sense that their parents are angry with one another or conducting a quiet war behind the scene. We want to continue to work as a team raising our children, to share in the major decisions, to support one another, and to share in the traditions and celebrations we have established. We want as little change for our children as possible." Now, that is a statement of purpose. Now, what does that do? Because that's a document that you can refer to throughout your
Yeah.
proceeding from that point onward that keeps you on task. I know the other way to do it is to try to get into what I call alternative dispute resolution modalities. One is
Okay.
mediation. We talked about mediation. We can have pre-filing mediation, provided that the part and try to resolve some of your issues, if not all of your issues, if you can. Of course, on the financial issues, that's difficult unless the attorneys have agreed to swap some financial information with one another, so that they can do due diligence to make sure that their client's not getting screwed
Hmm.
in the deal. But but again, so what are those? Mediation is one of them. Again, the closer you can get it up to mediation settlement from the time the divorce is set, excuse me, from the time the first petition is filed till the time mediation occurs, you want that to be a limited period of time.
Okay.
If you can, you file before the hearing, before the filing petition for divorce. That's called pre-filing mediation. You can have post-filing mediation done quickly also. Then there's the collaborative divorce. Collaborative divorce is a process where the parties sign a contract with their attorney saying that we're going to settle the case, we're going to meet privately, all the meetings are going to be confidential, and we run on a strict agenda. We don't talk about anything other than the agenda. If something else comes up, we'll do it at another meeting. We're supposed to be civil with one another. We're going to have a neutral financial professional who will gather all of the information, and we'll be completely transparent. If there's information requested from us financially or otherwise, we provide it. We have a mental health professional who acts as the facilitator, who
Mm.
runs the meeting. Now, when's the last time you were in any event with an attorney being involved where the attorneys didn't run the meeting?
Right.
I don't know of any. Now this, and they're done privately. Meetings are set up and they have an agenda and they work through the issues from beginning to end. And these meetings will be primarily dealing with financial issues because on the side, parallel to these meetings, the mental health professional is working with the parties to work out their parenting plan or custody/visitation agreement and other co-parenting issues. But the con that people get afraid of in the collaborative process, part of the process says, in the event that one of the parties drops out of the process and
Hmm.
goes to litigate, then you can't use your attorneys, can't use the, may not be able to use the individual professionals cannot testify, may be able to use the financial data that was gathered, but that's up to the parties to agree on. Now, one would ask, why would I ever agree to a process where if I someone dumps out, we got to start over? Because what it does is it puts, it recognizes the weaknesses and the shortcomings of the litigation approach, and that is this. I litigate all the time. I'm in court all the time. It's easy for me to say, if we can't settle it, we'll litigate it. And
Mm.
I'm also an ego-driven
Hmm.
individual. You can't survive law school and be a litigator without
Right.
having a healthy ego. Why is that? Because one day I'll go in front of a judge and anything I say will be taken like I'm a god. I can't say anything wrong. I'm praised to the heavens. Next day I come in, same fat pattern, same argument, and I'm worthless. Where do you get out of here with this idiocy? So it's easy because I have this high ego and I want to succeed. It's easy for me to say, "Oh, if we don't settle it with mediation, we'll litigate it." And it becomes a self-fulfilling prophecy because if I say, "Listen, we're going to do the parenting plan,
Right.
we'll decide on the property, we're never going to agree on the money, on income, and we never agree on income because it's easy for me to go litigate, not so much for you, and it costs you money to
Right.
litigate. It doesn't cost me anything. This is a process. So once an attorney's involved, if you take away his out, it's
Right.
easy for me to litigate. I lose the case in the client if I go to litigation. You now become focused on becoming the greatest problem solver in the world. You
Right.
say, aren't attorneys supposed to be problem solvers? Yes, but we're taught to be problem spotters.
Right.
That's what the key of law school is about. I don't know about you or most people's experience, but I know when I'm dealing with attorneys in my own individual life or business issues, when I have a meeting with them, I want to cut my wrist because it depends or it goes
Right.
from this place to that place. There's no clear answer.
Right.
So what we have then is if we take away the process of litigation being the result, I'm much more motivated to solve the
Wow.
problem than I was before. That's on the attorney's end. On the party's end, this uh, termination clause works for them because once they start paying money to get a process done, they want to start over.
Right.
So human nature recognizes the process of human nature and of the attorney's nature and how they deal with cases. So that's why if you're asking attorneys who deal actively in the collaborative process, they have the same success rate in terms of settling cases as they do with litigation, which is anywhere from 90 to 95%.
Wow. Wow. I mean, and I also, I mean, I have to imagine that in the collaborative process too, when you have a mental health professional kind of at the center of it, that there is potential for greater care to be taken about how to talk to kids about the process, how to involve them.
Absolutely, and that's what they're there for. I mean, and you can do that also in terms of a contested case. Provide you can bring in a consulting
Sure,
expert
sure.
who can help tell your client how to parent properly, and it's at no risk for the tactics or strategy of the case because it's a confidential advisor. They're not going to be testifying, therefore they don't have to be identified, nor can they be discovered. So you have someone coming and working with you and your client. Because believe me, when you're dealing with the loss issue,
Mm-hmm.
that clients are dealing with an emotional turmoil in their divorce, they often are not functioning at their best.
Right.
And everyone in those circumstances probably should have a therapist to help them deal with the
Yeah.
loss. And if that professional doesn't feel it's a conflict of interest, do so, coach them on how to be a better parent. Also, how to communicate.
Yeah.
I mean, we hear a lot nowadays about narcissism. You know, a few years ago it was borderline personality
Right.
disorder.
Yeah.
Um, we are all a little narcissistic when it comes to a divorce because it is about us, because we're dealing with our own personal loss. So and divorce doesn't bring out your best.
Right.
There's that expression. Criminals are people in criminal court are bad people trying to be their best to get the best result they can. People in family court are generally good people who are at their worst.
Well, and just that your mention of a mission statement, because I'm aware of a larger body of research about the power of mission statements in classrooms, for example. So if you have a school that is mission driven, where the students and faculty know the mission of that school, those schools tend to perform better academically and have better climates, so less bullying and less aggression, because it is this, you can appeal to it's an authority. It's not you don't say to somebody, I want you to do this. You say, hey, this is the mission and we need to act in accordance with it. And it seems to not only motivate, but it seems to keep people, give them a sense of purpose, but also it makes things slightly less personal, right? So I really like that aspect.
Yeah, absolutely. And again, you don't know how, for attorneys, what we're trying to do is manage our clients and guide them through this very frightening at times, frustrating at times, and anger producing at times process. And to have a mission statement that you can say, this is what you agreed to. This is when you were thinking clearly
Mm.
about what was best for your children and their future and your future with them. This is what you say is going to happen. Now, in a collaborative case, that's one of the first things I'm going to do is urge the parties, even before the first meeting, sit down and write out a mission statement. And if they need help from the mental health professional facilitator, they can call upon her to do so. But that mission statement is then read at the beginning of each meeting, even if it's just dealing with children. But we try to expand it on how they're going to deal with one another during this process and how they're going to deal with one another after, just not in terms of communication, but financially and other things. So it's an alternative dispute resolution method. It's non-litigation.
Yeah.
Litigation is going to become more and more difficult to participate in as time goes on, even though we seem to have this formalistic, what I call the formalistic
Right.
modification of judges' authorities in cases developing. You still are going to have circumstances where you're going to need this kind of mission statement to keep the parties on track and help guide them through even a litigation process. But it's even better in a collaborative process. And sometimes I'll even try to inject it into the form of pre-filing mediation.
Mm.
If we can't get anything decided except a mission statement, then it may be accomplished more than most people will in the beginning of their cases. I mean, anything that you can do to lower the tone
Right.
of the adversarial process, or to get the parties on track on trying to resolve the case, because everyone will say, I want to collaborate, I want to settle a case. Well, that is, however, even though we may have 90% of the cases settling, they're settling at the eve of trial. So there's a whole lot of stuff going on between the time you start a divorce case and the time you resolve it, if you're by settlement of some nature.
So, Charles, I have a question that's a little bit, it's a little off topic here, but one of the things that I'm constantly have to deal with when I'm in the public, when I'm working with families or communities, everybody complains a lot about kids and their devices, right? So kids online, kids in social media, and they talk about how it's impacting these young people. But I became aware of a statistic, and I just wanted to get your uh, reaction on it. According to the American Bar Association, the amount of digital correspondence that gets entered into divorce proceedings has skyrocketed because so many adults are initiating and carrying on affairs online, right? That they've met and I only bring that up because one of the things that first of all I wanted to know if that was your experience, but I also bring it up because one of the things that I believe is that if we want our kids to behave better in a given arena, whether or not that's in person or online, we need to behave better as adults in that arena. So, is it true that you have seen in your own practice this kind of explosion of emails and texts and social media being entered as evidence?
Oh, yeah. I mean, I like to say it's a treasure trove for divorce lawyers because people think, for some reason, they think whatever they're doing is private and it's not.
Right.
People will post online the most inane things. But I think one of the most grievous sins, as I would call it, is not instructing your friends to not post about you online. In other words, say you're at a party, you're at an event, or you're on vacation, and you don't post up anything about it. You don't say anything about it on your social media, but your friends who are there, they've got you in photos,
Yeah.
you're tagged. I mean, you're still there. You tell your clients, tell all of our clients, don't use social media during your divorce. Well, that's almost impossible to make. So if you're not going to do it, don't have it say anything about your spouse, your kids, or anything else.
Right.
And ask your friends not to do so. But again, I tell them, don't post on social media. They're posting anyways, and I know that, and they know that. So I tell them, don't post about yourself. Don't have anyone post about you. Uh, Go through your list. Block the people you think are allied to the other side. But understand that anything you put on the internet will and be seen by a judge. And I don't even tell them anymore to delete what they have
Right.
because you can never really delete.
Never delete.
There's ways to
Right.
do it. And you may get what I call the spoliation letter. Spoliation is a concept under the law that you can't destroy evidence.
Right.
So you can send a letter to the attorney representing the party saying, this is a note that they're not to delete, remove, or anyways modify
Right.
the social media content that they have. And by the way, here's a subpoena for it, or demand for documents. So it's there.
Of course, the real answer, Charles, to that is for them just to behave better. It isn't about how it gets recorded. How about you just behave better, regardless of whether or not it's being recorded?
Well, I know. Well, but again, people, I mean, I hear all the time, well, they did it, or someone
Right.
else has done it, or my cousin June did it. And oh, by the way, they can't tell me what to say or what to do. I mean, I tell them, I said, do you really want to have this stuff out there so your kids can see it?
Yeah.
Which is my other complaint about attorneys is filing. If you're going to put all the salacious stuff in your pleadings about the other parent, remember, at some juncture, everything in court, filed in court, is available to be seen on the internet in most jurisdictions.
Yeah.
Your kid becomes sophisticated enough use of the internet will eventually get a hold of these documents. What are you going to say about it? You can't delete them, you can't destroy them.
And
They're
all
there.
the and in the mediation and in the collaborative approach that you described, that isn't the case. Is that true?
Because we're paying attention to what's real.
Okay.
What's real is not what you posted. I mean, I try to advise my client, don't post anything on your social media that would
Right.
cause your spouse to go, go crazy or have an adverse reaction.
Right.
But try to be respectful about that. But you're correct, because we're paying attention to what needs to be paid attention to. If we saw something was going on like that and it became an issue, the facilitator probably would sit down with the parties, both of them, and the offending party in particular, and say, stop the nonsense. I said the other one thing I did not mention about the facilitator is like the monitor of the process. The parties start getting a little heated, they're not speaking appropriately or respectfully to one another. She'll call a timeout and sit down and with the attorneys and say, cool it. And that's not unusual. There's a different form of advocacy going on here.
That's amazing. Well, Charles, I think that I could continue. I know that you have such a rich career. We could continue to talk about this for a very long time, but our time is almost up. And I just wanted to, first of all, I wanted to thank you for keeping the child center in this legal process. There are so many legal processes that impact kids where their needs and the impact on them is not considered. So thank you so much for your work in keeping the needs and interests of the child center. And thank you so much for being a guest on Talking About Kids.
It's certainly my pleasure to be here, Brad. And, anytime, let me know.
Thank you.
Glad to come back.
That was Charles Jamieson. More information about Charles and his practice can be found at talkingaboutkids.com. From there, you also can find out about upcoming episodes, suggest a topic, learn more about me and my books, or submit your questions for future guests. Our theme song is by The Senators. For more of their music, go to thesenatorsmusic.com. And remember, kids are young goats and young humans. And the difference is that young goats are easier to manage.